Good evening to the participants of the JCJ and both the Telangana state as well as Andhra Pradesh. Yes, what I posted on the screen, can you read it? Participants, can you unmute and read what I posted on the screen?
Welcome to the aspirants of JCJ 2023 virtual class. Indian Standard
Yes.
Time 8:30 p.m. to 9:10 p.m. Property transfer, sale, mortgage, lease, gift, exchange, actionable claims.
Yes, these are the things which will be there in the Transfer Property Act. Yet, without wasting the time, let me start the shooting now. Number one, question. The Transfer Property Act 1882 is an Indian legislation that regulates the transfer of property in India. It contains the specific provisions regarding what constitutes a transfer and the conditions attached to it. It came into force on dash 1882. A. 1st June. B. 1st July. C. 2nd July. D. 2nd July.
B. 1st July.
It is the answer is the 1st July is the right answer. It is the easy question first I framed. Okay. Second question. The Transfer of Property Act 1882 is one of the dash laws and was enforced on July 1st, 1882. A. UK. B. British. C. Colonial. D. English.
B. British.
WRONG.
Colonial. C.
C is a colonial laws and was enforced on the July 1st, 1982. Then the third question. Before the Act, property disputes in India were governed by the British, following the dash legal principles such as equity, justice, and good conscience. A. UK. B. British. C. Colonial. D. English.
English. D.
WRONG.
B. British.
B. British. See, when you say English law, but when you say legal principle, we say British legal principles. We don't say English legal principles. Now the fourth question. The Transfer Property Act 1882 has how many times word property is mentioned in the entire act? Yes.
B. 403.
It's not so clearly mentioned. It is, you said 403. What is it? Property. Is it not? PROPERTY. PROPERTY. I don't know why it is not typing. Yeah, it is 402 is the right answer. Okay, now let us go to the next question. Fifth question. What is the exact or correct sequence under the Transfer of Property Act? Sale, lease, gift. I forgotten to keep the exchange also. Mortgage. B. Sale, mortgage, gift, lease. C. Sale, mortgage, lease, gift. D. Sale, gift, mortgage, lease. Which is the proper sequence?
C. Sale, mortgage, lease, gift.
Suppose if it is exchange is there, where it comes?
118. After lease.
Okay. Now next question. The Law of Property Act was indeed based on the provisions of the English property law. Yes. Now you tell me, I will give the 100 rupees. A. The Law of Property and Conveyancing Act of 1881. B. The Law of Conveyancing and Property Act of 1881. C. The Law of the Conveyancing and Property Act of 1882. D. The Law of the Property and Conveyancing Act of 1882. 100 rupees.
The Law of Property and Conveyancing Act 1881A.
Intentionally I kept it. You are a loser. That's why I put the 100 rupees here. It is the right answer is the Law of Conveyancing and Property Act of 1881. That is the right answer. Yes. The seventh question. The transfer of property is governed by the rule of dash, which states that the transferor can only transfer those interests that himself holds to the transferee. And the maxim is A. Nemo dat quid non habet. B. Nemo dat quid non habet. C. Nemo dat quid non habet. D. Nemo dat quid non habet. I made only the spelling change.
Option A, nemo dat quid non habet.
WRONG. It's
C,
a tough
sir.
question.
C.
Unless you know it very strongly. Yeah. Nemo dat, C is the right answer. Nemo dat quad non habet. That is the right answer. C is the right answer. CAT cat is the right answer. Okay, now, eighth question. There are various ways to transfer a property and Transfer of Property Act. Those are as follows. A. 1. Sale. B. Gift. 3. Will. 4. Mortgage. A. 1 plus 2 plus 3. B. 1 plus 3 plus 4. C. 2 plus 3 plus 4. D. 1 plus 2 plus 4.
D. 1 plus 2 plus 4.
Repeat.
D. 1 plus 2 plus 4.
WRONG. No, it is right. 1 plus 2, because there is no will. Okay, now ninth question. As per the section 3, immobile property does not include the standing timber, growing crop and grass. The word standing timber includes the babul tree, shisham, nim, papal banya, teak tree, bamboo, the fruit bearing the trees like the mango, mahua, jackfruit, jamun, etc. are not standing timbers and they are immobile properties. Was observed in the case of dash. A. Fatima Bibi versus Arfan Begum. B. Ruxana Khatun versus Arfan Begum. C. Shahana Bibi versus Arfana Khatun. C. Reshma Bibi versus Arfana Begum.
A. Fatima Bibi versus Arfana Begum.
You are right. It is the Fatima Bibi versus Arfana Begum is the right answer. And 10th question, there are other ways also the transfer of property which are as follows. 1. Relinquishment. 2. Lease. 3. Rent. 4. Lease, leave and license agreement. Option A, 1 plus 2 plus 3. B, 2 plus 3 plus 4. C, 1 plus 2 plus 4. D, 1 plus 3 plus 4.
B, sir.
Full.
2 plus 3 plus 4. Lease, rent, leave and license agreement.
The right answer is C, 1 plus 2 plus 4. Leave license agreement is there, relinquishment is there, lease is there, but rent is not there, but I put the rent. Okay, 11th question. Which option is the correct option among the 4 options? Here 4 options are given. Number A, the transfer of property can be made as a future date also. However, at the future date, the property must be present in the name of the transferor. The transfer of the future property whose existence is uncertain is not a valid transfer. B, the transfer of property can be made at a future date also. However, at the future date, the property must be present in the name of the transferee. The transfer of the future property whose existence is uncertain is not a valid transfer. C. The transfer of property can be made at the future date also. However, at the future date, the property must be present in the name of the transferor. The transfer of the future property whose existence is uncertain is a valid transfer. D. The transfer of property can be made the future date also. However, at the future date, the property must be existing in the name of the transferor. The transfer of the future property whose existence is uncertain is not a valid transfer. So I made A,
D,
B,
sir.
C, D. Which one is the right answer?
D. D.
Full D for dog.
Yes, sir.
You want to say D. This one.
Yes, sir.
Wrong.
Yes, sir. A.
A is the right answer. The transfer of property can be made at a future date also. However, at the future date, the property must be present in the name of the transferor. The transfer of the future property whose existence is uncertain is not a valid transfer. What is the B wrong?
Transferee is there, sir. Not transferer is the correct answer.
Yes. And the C is?
C also, it's uncertain, whose existence is uncertain, is valid transfer is wrong, sir. It's not valid.
Yes. Then D.
D, I'm quite confused.
The property must be, the host make it existing in the name. Existence is not there. Presence. Existence is not there. Existing is not there. Yeah. Present is there. Must be present. But I wrote existence.
Sir.
Present. Where is the present?
Yes, sir. Yes, sir.
No. Let me check. Uncertain is not. Yeah, something wrong is there because the property must be present. But the host make it existing in the name. Anyway, that A is the right answer. So section 49 capital A, reference to mortgager and mortgagees to include the persons deriving title from them. Which option is the correct option? A. Unless otherwise expressly provided, reference in this chapter to the mortgager and mortgagee shall be deemed to include the reference to persons deriving title from them respectively. B. Unless otherwise expressly provided, a reference in this chapter to mortgager and mortgagee shall deem to include the reference to person deriving title from them respectively. C. Unless otherwise expressly provided, reference in this chapter to mortgager and mortgagee shall be deemed to include the reference to the person deriving title from them respectively. D. Unless otherwise expressly provided, reference in this chapter to mortgager and mortgagee shall be deemed to include the reference to persons deriving title from them respectively. A, B, C, D. Which one is the right answer?
Sir, A, C, D, three are similar, no, sir?
Which one?
A, C, D, three are similar.
No, I made changes.
End. Yeah.
I made
N
changes here
symbol
and
is
there.
uh,
If you happen to see B,
End symbol.
mortgagee shall be deemed. There shall be deemed. I removed the shall be deemed to include reference to, but the host change
C.
shall deemed. Shall deemed.
D is the right answer.
Then in the D, in the chapter mortgager, but the host changed in this chapter to mortgager.
Yes, sir. Yes. A is the
So
right
A
answer.
is the right answer. Okay. 13th question. The court in the crucial case of dash and others, and others should have to come there. I made it clear that the transferee need not have total possession of an immovable property specified in the contract in order to avail himself in the benefit of the remedies of the section 53A capital A of the Act. A. Nathulal versus Pulchand. B. D.S. Parvatama versus Srinivasan. C. Durga Prasad and others versus Kanhaiya Lal and others. And D. B. Paramashivaya. Yes, Paramashivaya and others versus M.K. Shankar Prasad and others.
A. Nathulal versus Pulchand.
WRONG. The right answer is Durga Prasad and others versus Kanhaiya Lal and others. C is the right answer. Now 14th question. Yes. Unmute and read.
Immediate family members like his dash can claim his property after his death under Class 1 of Hindu Succession Act. 1 son, 2 husband, 3 daughter, 4 mother. A 1 plus 2 plus 3, B 1 plus 3 plus 4, C 2 plus 3 plus 4, D 1 plus 2 plus 3 plus 4. 1 plus 2 plus 3, A.
WRONG.
C, sir.
See,
1 plus 2 plus 3 plus 4.
if you just logically you mean who died? Who died?
Father,
Husband died.
husband.
So, if the husband died, where the husband comes in the two? Wife. I removed the wife, I put the husband. Is it clear? Then the right answer is
1 plus 3 plus 4, B.
1 plus 3 plus 4 is the right answer. Now, 15th question. The two landmark cases that helped to develop the doctrine of the part performance were dash 1883 and dash 1882. Apart from this, we can conceptualize the doctrine of part performance with the judicial interpretation of the following cases. A. Madison versus Alderson and Walsh versus Lonsdale. B. Anderson versus Madison and Lonsdale versus Walsh. C. Anderson versus Lonsdale and Madison versus Walsh. D. Walsh versus Anderson and Madison versus Lonsdale. It is also a bit tough question. But I
B,
don't
sir.
want to keep Zawadi. What are the two
B, sir.
English cases?
Alderson versus Madison and Lonsdale versus Walsh.
The right answer is Madison
B.
versus Alderson and Walsh versus Langsdale. That is A. Is it clear?
Yes, sir.
Madison versus Alderson 1883 and Walsh versus Langsdale 1882, because the English case law, from there it actually part performance has come, which is section 53 capital A. Okay, now let us come to, I think I am right, 53 capital A, subject to the correction. 16th question, example of the immovable property. Number 1, chattels embedded in the earth. 2, easement. 3, right of way. 4, right of enjoyment of the immovable property under the lease. Options: A, 1 plus 2 plus 3, B, 2 plus 3 plus 4, C, 1 plus 3 plus 1 plus 3 plus 4, D, 1 plus 2 plus 3 plus 4.
D 1 plus 2 plus 3 plus 4.
Yes, it is the right answer, because everything is attached to the earth is there, easement is there, and the right of way is there. Yes. 17th question. Example of the immovable property. 1. A right of fisheries, and 2. A right to collect the rent of immovable property. 3. Interest of the mortgager. 4. Grass. And A 1 plus 2 plus 3, B 1 plus 3 plus 4, 2. C 2 plus 3 plus 4, D 1 plus 2 plus 3 plus 4.
A 1 plus 2 plus 3.
A 1 plus 2 plus 3, because grass is come under the movable property.
Not an immobile property.
Yes. 18th question. Surrender. It is not the transfer. It is the manager of the lesser estate with a greater one was observed in the case of dash. A. Maltan Lal Saha versus Nagendra Nath Adhikari. B. Govind Chandra versus Dwarkanath. C. Maniappa Pillai versus Periyar Swami. And D. Hussia Banu versus Shivanarayan.
C. Maniappa Pillai versus Periyaswamy.
WRONG.
B. Govinda Chandra versus Dwarkanath.
WRONG.
A. Multan Lal Saha
Multan
versus
Lal Saha
Nagendranath.
versus Nagendranath Adhikari is the right answer. Now, match the following terms of the Part A and the section from Part B, the Transfer Property Act. Gift defined and mortgage appeared, lease appeared, sale defined, and Part A. Part B, A 54, B 64, C 58, D 122. Now options I have given here. A 1D 2C 3B 4A, B 1A 2C 3D 4B, C 1B 2A 3C 4D, D 1C 2B 3D 4A.
A. 1D 2C 3B 4A.
The right answer is 1D 2C 3B 4A because exchange is defined. Of course, I did not put the exchange there. It's 118. Gift defined 122. Mortgage appeared in
Sir,
58.
lease is
appeared.
wrong, sir. Lease is 105.
No, in the lease, no, first appeared. Appeared, I said. Lease appeared first, not defined. Appeared. Sale defined. Appeared is different and defined is different. Appeared means where it comes in the first. Defined means it comes maybe because appeared may also come in the chapter or in the other sections also. So appeared is different and defined is different. Is it clear?
Yes, sir. Yes, sir.
Please, that's why, please, define is different, appear is different. It may appear in any section also, lease. Any section. The first appearance. Define means clearly definition. So, in the exam, they will confuse you. Please make this very much clear. Okay?
Yes, sir.
Yeah, because I intentionally kept it. Must appeared, not defined. That's why I clearly wrote gift defined, exchange defined, mortgage appeared, lease appeared, sale defined. Is it clear? Okay, 20th question.
Yes, yes, sir.
Part performance under the section 53 capital A of the Transfer Property Act 1882 give rise to the statutory right of the defense as mentioned in the case of dash. A. Srimati Hamida versus Srimati Humar and others. B. Ramlal Sahu versus MT Bibi Zohra. And C. Govind Prasad Dubey versus Chandra Mohan Agnihotri and other. And D. Hamid versus Jaya Bharat Credit and Investment Company and others.
C. Govind Prasad Dubey versus Chandra Mohari Agnihotri and others.
WRONG.
B. Ramlal Sahu versus
Ramlal
MT.
Sahu versus Bibi Zohra. That is the right answer. 21st question. Mere delivery from one person to another does not constitute a valid transfer of the movable property. The said property which values at more than 100 should be compulsorily be registered under dash. A. Indian Revenue Act. B. Indian Land Registration Act. C. Indian Registration Act. D. Indian Stamp Act.
D. Stamp Act.
WRONG.
Registration Act.
Kept.
Registration Act. C.
Registration Act it is. I thought you want to confuse them. Yes, better you write because people will say Indian Stamp Act immediately. It is the Indian Registration Act. Is the right answer. 22nd question. One of the most important judgment in this regard is the case of dash. In this case, certain sections of the Karnataka Scheduled Caste and Scheduled Tribe within parentheses prohibition of the transfer of certain lands act were in conflict with the section 51 of the Transfer Property Act. In which case law it is? A. Western Coalfield Limited and other versus sale of state of MP and others. And B. Himangini Enterprise versus Kamaljit Singh Ahulwalia. And C. Harishchandra Hegde versus State of Karnataka. D. State of Punjab versus Baldev Singh and others. It's a very famous case law. Transfer of
State of
Property
Punjab
Act will
versus
not be applicable when there is a special act is there. The special act will eclipse the Transfer of Property Act.
D, sir. State of Punjab versus Baldev Singh and
No.
others.
It's a very famous case law. Harishchandra Hegde versus State of Karnataka. When there is a special act is there, at that instance, the Transfer of Property Act will be eclipsed. No more applicable in the conflict of this section 51 of the Transfer of Property Act. Okay, 23rd origin of the doctrine of part performance in dash law. A. English. B. American. C. British. D. Canadian.
B, American.
Doctrine of part performance derived from the English law. Okay, 24th question. In the case of dash 1872, the court has explained that the movability may be defined to be the capacity in a thing of suffering alteration. On the other hand, if a thing cannot change its place without injury to the quality is immovable. A. Shiromani Gurudwara Prabandhak Committee versus Amritsar versus Sri Somnath Das, and B. Shantabai versus State of Bombay. C. Sukri Kurdepa versus Gundakul, and D. Govind Chandra versus Dwarkanath.
B, Shantabai versus State of Bombay.
WRONG.
D, Govind Chandra versus Dwarkanath.
WRONG. The right answer is
Yes,
C. Sukri Kurdepa versus Gunda Kul. In that case, slide is decided. Now, 25th question. Does the section 6 containing the clause A to 1 specifically mention that certain things cannot be transferred? Such a transfer, if undertaken, would be invalid in the eye of the law in India. How many clauses from A to 1 I in the total? A. 8, B. 9, C. 10, D. 11.
8, sir.
WRONG. If you count A to I, how many will come? It will come
8.
only. How many come? 9 it will come.
9.
But 9 is not an
9.
answer because I want to give the 100 rupees here, Zawadi, but I don't want because it is an easy question. D is double. D is there and DD is there. So the right answer is? Right answer is?
Sorry, I could not get you, sir.
See, if you count A, B to I, how many are there? A, B, C,
9.
D, E, F, G, H, I. How many are there?
9.
9. But the D is there, no? DD is another section is there. DD, class DD.
Acha. Okay.
So,
10 is the answer.
I want to keep 100 rupees Zawadi, but I know sometimes you can make it out DD. So, DD is there, hence, which is the right answer?
C10.
C10 is the right answer. But I can keep the Zawadi for another thing because that is the toughest one. Okay, the respondent here in plaintiff filed a civil suit under 70 of the 1988 for the possession of the land measuring the 11 Biswaganis comprised of the Khashra 1999 in the Talima of the demolition of the structure up to the therein party Dhalpura, Koti Maharaja, Tehsil and district Kullu and permanent prohibitory injunctions restraining the defendant appellant herein from the interfering the disputed land, other land appurtenant and the total same after the demolition of the structure put up there was ordered in the case of. This is the case of Maharaja Kothi, in which case these facts are there. A. Pratima Chaudhary versus Kalpana Mukherjee and others, And B. Baini Prasad D. through the LRS versus Durga Devi. C. Ram Prakash Sharma versus Babulal. And D. Ghisa Lal versus Dhapubai.
C, sir. Ram Prakash Sharma versus Babulal.
WRONG. The right answer is Baini Prasad deceased through the legal representative versus Durga Devi. That is the right answer of the above respondent civil suit. Now the 27th question. Transfer of actionable claims are provided under the dash of the Transfer of Property 1882. A. Section 128. B. Section 129. C. Section 130. D. Section 131.
C 130.
C 130. Actionable claim in which type of the property it comes?
Immovable property.
No, yes, it's the immovable property. Is it tangible or intangible? Intangible.
Intangible.
Yes. If you give the right answer for this one, I will can give the 100 rupees as is awarded to you. Chandigarh monumental architecture is enunciated by the Lee Corbusier. Is based on the principle of the town planning concept of the sun, space, and Virtue. De Corbusier incorporated the principle of the light, space, and glossary in the plan and used the human body of the metaphor as a head contained in the capital complex and heart being the commercial sector 17 lungs and the leisure's valley, innumerable open spaces, sector greens, the intellectual and the cultural and the educational institution, the viscera, the industrial area, and the arms having the academic and leisure facilities like the open courtyard. The circulation system was conceived having the 7 types of the road known as 7 V's are the facts of the which case law. See A, B, C, D. I have given A. Kuchukunju Nair Welfare Association was the Union Territory of the Chandigarh. B. Koshi Alexander Welfare Association was the Union of Territory of Chandigarh. D. C. Residents Welfare Association was the Union of Territory of the Chandigarh. And D. Chandigarh Welfare Association was the Union Territory of the Chandigarh. In which case law this is decided? I put all that at one place.
B.
Yes?
B.
Wrong.
Koshi Alex.
That's why I kept 100 rupees today. Koshi Alexander Welfare Association versus the Union of Territory of Chandigarh. I concocted, I fabricated to see that everything should be very close to it. But the right answer is C. Residents Welfare Association versus the Union Territory of Chandigarh. So, who is the Chandigarh engineer? Is a planned city. The only one city in a big city in India with a planned city is Chandigarh. Next, Bangalore. Okay, 29th. The phrase living person includes a dash or association or a body of individuals, whether incorporated or not, but nothing in this section shall affect any law for the time being in force relating to or by companies, associations, or bodies, individuals. A. Corporation. B. Firm. C. Establishment. D. Company.
D. Company.
Company is the right answer. 30th question. Therefore, in cases where the transfer is made under certain other laws and the act would not applicable, the act also is not applicable to cases where the provisions of the special legislation are in the conflict with the provisions of the act. This was held in the case of dash. After the judgment passed in the case, it has been the authority in case of the reflecting the conflicts between the special laws and the Transfer of Property Act, which is the case law. A. Western Coalfield Limited and others versus State of MP and others. B. Hemangni Enterprises versus Kamaljeet Singh Ahluwalia. C. Harish Chandra Hegde. I think I already dealt this case law. I already dealt this case law. Because when the special act is there, the Transfer of Property Act will not work. What is the case law name?
Harishchandra Hedge was the
Harishchandra
state of
Hegde was
Karnataka.
the state of Karnataka. That is the case law. One of the most important judgment in this regard in the case of Harishchandra Hegde versus state of Karnataka. In this case, certain sections of the Karnataka scheduled caste and scheduled tribe prohibition of the act were in conflict with the dash of the I already dealt it, this one, the Transfer of Property Act already dealt. What is the right answer?
A51.
51, I already dealt this. Okay, the rule that a condition of a dash restraint is void is based on the principle of the public policy allowing the free circulation and disposal of the property. A, absolute. B, complete. C, unqualified. D, total.
A, absolute.
It is the absolute. 33rd question. Absolute interest implies that which option is the correct option among the four of the following. 1. There should be a transfer of property. 2. There should not be a transfer of property. 3. An interest in the property in favor of the transferee should be created. 4. The term of transfer should direct that such a transfer shall not be applied for the enjoyment in a particular manner only. And then A, 1 plus 2, B, 1 plus 3, C, 1 plus 4, D, 2 plus 3.
B, 1 plus 3.
Repeat.
B, 1 plus 3.
Yes, you are right. It is a B, 1 plus 3 because 2, 4 is not the right answer. Because I fabricated wrong there. And 4 added after that shall be, shall not be. So that is the 34th question. A careful reading of the section 11 helps us understand the second paragraph of the section states the exception that has been provided by the act. The second paragraph, the state like that A, where any such direction has been made in respect of one piece of immovable property for the purpose of securing the beneficial enjoyment of the another piece of such property, nothing in this section shall be considered to affect any right with the transfer may have to enforce such a direction or any remedy which he may have in respect of a breach thereof. B, where any such direction has been made in respect of one piece of immovable property for the purpose of securing the beneficial enjoyment of another piece of such property, nothing in this section shall be deemed to affect the right with the transfer may have to enforce the such direction or any remedy which may have in respect of breach thereof. C, where any such direction has been made in respect of one piece of immovable property for the purpose of securing the beneficial enjoyment of the another piece of such immovable property, nothing in this section shall be deemed to affect the right which the transferor may have no enforce such a direction or any other remedy which he may have in respect of breach thereof. Then the last is D, where any such direction has been made in respect of one piece of movable property for the purpose of securing the beneficial enjoyment of another piece of such property, nothing in this section shall be deemed to affect any right which the transferor may have to enforce such a direction or any remedy which he may have in respect of a breach thereof. So I made here A, B, C,
B.
D.
जनगणमन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड़ उत्कल बंगा
सारे जहां से अच्छा हिंदुस्तान हमारा। जय हिंद।
Jai Hind.